discuss legal reasons. Health and safety law is important because people, organization, money-minded businesses do not follow the rule of law and want to have chaos, maximum profit on the other's life. So the law protect our general safety and ensure our right as citizen against abuses by other people and by the organization. The chief uses or advantage of law are in number like uniformity and certainty about the law. There is a equality and there is a no partiality. It's having the trait of the impartiality and it is protection from errors and it having the reliability. So health and safety laws carrying this type of a advantages which apply to all the industries. The legal region concerning the employee duty of care in criminal and the civil law. Legal enforcement indicate the legal consequences resulting from breaches in health and safety law. Responsibilities of the employer to implement the rules and regulation at the workplace for ensuring the safety at the workplace. So these are the legal region background. The legal region will have a preventative approach or the proactive approach and help to preventive detention, on the other hand, means detention of a person without trial and conviction by a court. If any major accident happen at the site and 2, 3 fatality happen, then legal authority will be forced to have a detention of the duty holders to prevent the further accident at the site. The punitive action to inflict a penalty on or a type of a punishment to the duty holders is to punish a person for a offense committed by him after trial and conviction in a court. And the another compensatory effect of law that after any accident happened, the compensation will be paid to the victims to live his life or to his dependents. And the principle of self-regulation that every employer or organization need to follow the certain health and safety regulations to prevent any major accident or catastrophic failure at the site. We can see the preventive action wants to avoid by the every organization to avoid the preventive action. If we don't follow the health and safety law, the legal implication will be there. If we breach the health and safety rules and regulation, these action will be taken against the duty holder or by the against the management who is having the authority to take the decisions or against the employer. The punitive action to avoid the punitive action, the punishment, they want to avoid the punishment, prosecution to avoid the prosecution, and imprisonment to avoid the imprisonment. So every businesses wants to avoid this legal action against them. So legal health and safety rules and regulation may be the breaches by the various employer. So we must know as per the MHSWR 99 what are the legal requirement to be fulfilled by the organization. The MHSWR is the Management of Health and Safety at Work regulation and can be you can access this particular information from the www.legislation.gov.uk. So, as per this regulation, risk assessment to be done by the employer or by the organization. They need to implement the principle of prevention to be applied, health and safety arrangement to be provided at the organization, health surveillance to be conducted, health and safety assistance to be provided. There should be the procedures like safe operating procedures or any other emergency procedure for serious and imminent danger and for the danger area to be developed by the organization. The contact with the external services in the case of emergency like fire brigade, police, etc. to be make the provision by the organization, and information related to health and safety to be provided to the employee. In terms of health and safety, proper cooperation and coordination to be done by the organization. The person working in host, employer, or self-employed person undertaking also to be protected by the organization. The organization has to work out on the health and safety capabilities and training to be provided to all the workers who are coming at the workplace. The employees' duties to be fulfilled by the employees, but the workers or employees should be aware about their duties. The protection or the health and safety to be provided to temporary workers, and risk assessment to be done in respect of new or expectant mothers. The certificate from the registered medical practitioner in respect of new or expected mothers to be achieved and to be displayed and to be record to be kept. The notification by new or expectant mothers to be considered, and is a duty of organization to protection of the young person once they are coming while they are coming at the workplace. So these are the legal requirements as per the MHSWR 1999, which has to be complied by all the factory or the organization to avoid any legal action against them. There are the various legal instrument or act or regulation are available like legal law. It coming into the two major category, the civil law and the criminal law. There will be the prosecution by the enforcement agency if there is a breach of law. We must know or we must have the idea about the HASWA Act 1974, Health and Safety at Work Act 1974 UK, and MHSWR 1999, Management of Health and Safety at Work Regulation UK, the REDOR 2013, the Reporting of Injuries, Disease, and Dangerous Occurrence Regulations UK, the various ILO convention and recommendation, especially the R164, recommendation number R164, and convention number C155, the various statutory guidelines and requirement to be considered, and the various national law and the local laws also will be considered. So these are the rules applied to the any organization, and they need to follow these legal requirements to avoid any accident or any prevent any legal action against them. What enforcement agencies do and what happens if you do not comply, that we will see in the coming slides. The role of enforcement agencies. The enforcement agencies take enforcement action against the duty holders if they fail to achieve ILO convention and recommendation or the national law like HASWA Act 1974, MHSWR 1999. It may lead to enforcement action by the authorities, including the prosecution, penalties, punishment, punitive action before the court. Now we see the role of the enforcement agency. In the various places, it may be known as the regulating authority or the competent authority or the legal authority, or sometimes we directly call them like a labor inspector. So as a regulating authority, they have aimed to prevent workplace death or fatality, injury, accident, or ill health. To achieve this, regulating authority use various methods to influence changes and help organization or the people to manage the risk at the workplace. So they are responsible for enforcing health and safety law, legislation, or regulation like function of labor inspector as per Convention 081 of ILO. To enforce the health and safety law associated with working condition, this mentioned into the Convention 081 of ILO, function of the labor inspector. To protect workers while at work, to provide technical information related to health and safety, to ensure the legal compliances requirements are fulfilled at the workplace, provide health and safety policy assistance and implementation and purpose to prevent the accident, as per the Convention 081 of ILO, where it is under the heading of function of labor inspector. To provide advice to workers and employers on health and safety, to provide warning to workers and employers, action by labor inspector as per Convention 081 of ILO, to submit report to labor inspectorate, that is their office. Further role we see to make immediate executory orders in case of imminent danger at site, to take legal proceeding and action in case of violation of local or national law, advise on stopping the dangerous work activities, provide health and safety information, provide guidance on health and safety implementation, raising the awareness in workplace by influencing and engaging, operating permission and licensing activities in major hazard industries, and they deal immediately with the serious risk so they can prevent the harm as labor inspector visited. They carry out the targeted inspection, they investigate the workplace accident, they take formal enforcement action for not complying with the law and issue the formal orders like improvement notice or provision notice, take civil actions, issue improvement notice, issue enforcement notices in relation to any non-compliances of the legal requirements. They start criminal proceeding and they impose the fine. They take the punitive action. They take the prosecution action. They take the criminal action like imprisonment. They take action to control the risk if employer not complying with the law. They study trend and pattern of the accident or incident at the workplace. They prioritize the highest risk and those business which fail to manage health and safety properly. They recover cost from the employer by charging a fees for the time and effort it is spent on the helping. They claim the compensation for the victim or injured people. So we can see the possible question like what are the functions of the labor inspection or the labor inspector. Now again we see the role of HSC inspector in brief how they inspect. So when HSC inspector get information and intelligence that health and safety is a significant concern or any major accident happen, they inspect previous health and safety performance of the organization. They check concern or complaints raised by the workers, by the public and other union members or any other social groups. They inspect incident investigation like previous reports, current status of the previous accident and their investigation status. They inspect report of injuries, disease and dangerous occurrences like they check the accident book or accident register, incident forms. They inspect the workplace for health and safety implementation like unsafe act and unsafe condition. While they are at the workplace, they are going to watch this. They verify the legal compliances implementation. How labor inspectors carry out the inspection or during the inspection. The inspector, they inspect, they speak to relevant people, for example, with the managers, supervisors, workers and employee representative. They observe a sample of workplace activities, condition and practices. They assess the relevant document if necessary, check whether risk control are effective, identify any breach of the health and safety law, consider the appropriate enforcement, consider the prosecution, consider the penalty, fine, imprisonment action, issue improvement notices, and issue provision notices, and advise on the health and safety. So we can see what are the possible question can be asked in our exam. What are the action the labor inspector could take following the visit? And this information can be referred from the www.hsc.gov.uk. Now we see the limitation of the legislation or the rules. Sometimes the legislation or the act are inflexible or rigid, and it may require the frequent revision, likely to become out of date very soon. For example, the world has suffered from the COVID-19, but all the legal requirement could not be updated immediately. So then it takes some time and require higher level of expertise to achieve the compliances, and open to wide interpretation is required, and sometimes difficult to enforce lack of clarity. Like any PUWER, provision and use of work equipment regulation, the people who are familiar with the work equipment and their importance, their manufacturing aspect, their operating aspect, they people can implement the PUWER regulation. PUWR is a regulation can be find out on the HSC website. Again, I will repeat PUWR, provision and use of work equipment regulation. So that is the way that it required the competent people who are having the familiarity with this legal system applied to wide variety of workplace. There is a no specific workplace not considered. Suppose you want to have a new type of a design, new type of a building, new type of a risk initiated, uh, or maybe the developed at your workplace. So then this will be this legislation will be having the existing risk which occurred till date, and sometime the national level uh, legislation does not account of the local law or rules. So there are some limitations are there, but by the regular uh, interacting with the legal authorities, the solution can be find out by discussing with them, and when they realize they have their own certain protocol, when they realize this is a something not covered by the legal system, then they try to give the advice to the employer to prevent accident and ill health issues at the workplace. What happens if you or employer do not comply? Or what are the consequences of non-compliances? We can see. So if any organization or any duty holder not fulfilling the legal requirement, so breach of health and safety legislation will be considered as a criminal offense, and which lead to the enforcement action. There are chances of issue the verbal advisory warning, issue written improvement notice or prohibition notice, withdrawing the approval or revoke their approvals. They may vary the license, condition or exemptions for the organization. They may apply the fine. The enforcement agency like labor inspector or factory inspector or HSC inspector, whatever the name we call them, can still control the fulfillment of legal obligation and can impose punishment and penalty on the organization or the duty holder. They will do the prosecution in the criminal court, and outcome may be the fine or imprisonment or both for the individual or the organization after the judge decision. The legal action they will be taking against the employee or employer, they may make him banning from the job or the business. They may announce him as a blacklist or insolvent, or may announce him the bankrupt or the defaulter. So that particular employee or employer who has breached the health and safety regulation and resulted into the major accident, then that person or the employer or the organization or the employee, yeah, will have to face the legal action. The claiming compensation, because the workers will not have any idea from how to get compensation if any fatality happen or any major accident happen. So financial compensation to the workers who become ill health or involved in the accident may include, with the help of legal authorities, they will try to get the compensation from the organizations or through their insurance service, and provide the compensation to the victims. It may be in the various form like indemnification, like as per harm or loss. Some monetary benefit or remuneration will be given to the injured worker or victim. or deferred compensation in the form of pension plans or in the form of shares, or the job may be provided to their suitable uh, kids, not kids, we will say the adult son or daughter. So these help it done by the legal authorities for the victim worker or employee. The legal authority issues various type of a enforcement action. The two main important improvement notice and prohibition notice we will study in brief. The various types of notice issued by the legal authority, that is the improvement notice, prohibition notice, selection of the appropriate notice, and crown enforcement notices. Now we see the improvement notice. Enforcement agency may serve an improvement notice if they believe like employer is breaking the health and safety law, for specifying the period for compliance, like they will give the time like 2 months, 3 months, depend upon the type of the breach and the severity level, whatever they have considered. In that period, the recipient of the improvement notice may lodge an appeal with the employment tribunal. So the organization may implement the improvement at their workplace, and then they can go to the tribunal and they can appeal to take back this improvement notice. So this is issued by the legal authorities when they find any health and safety standard are not adequate. The enforcement agency serve a prohibition notice on employer or on the organization if any activity is in question has been carried out, so they can, but has been temporarily suspended as a result of accident. So legal authority will issuing a legal notice to stop the dangerous activities. If an HSC inspector see a need to prevent or stop the unsafe practices or any dangerous activities and serious breaches of health and safety in any organization, then inspector can issue a prohibition notice. So these are the legal power the labor inspector got, and they issue this type of a notice, and the organization has to serve that notice, and then it will be required to fulfill the requirement of that notice. So why an organization is complying the legal requirement? Generally, in the various employers feel that legal requirement is very important, and so we can see what are the basic they are complying the legal requirements, because breach of health and safety legislation is a criminal offense. So to avoid the enforcement action against the organization or the duty holder, to avoid the improvement notice against the organization, to avoid the prohibition notice, to avoid any enforcement action, to prevent the legal authority to withdrawing their approvals, to protect from wearing license, condition or exemption by the legal authorities, to avoid the fine uh, that need to be paid to the enforcement authority, to avoid the punishment, to avoid the penalty from the enforcement agencies, to avoid the prosecution in criminal court, to avoid the imprisonment for individual or organization or both, to avoid the legal action against the employee or employer and banning from the to them to business. So again, they will not repeat same type of a major accident or catastrophic failure at the workplace, to avoid the legal prosecution, to avoid the compensation, that money will be paid to the injured person. Sometimes this compensation amount is very high amount, and the company financial stability will become the unstable, like multiple fatality happened, like in Bhopal gas tragedy. To avoid the criminal court action, like imprisonment of managers who are the in charge of the health and safety, having the authority and having the duty of power, to avoid the reputation damages, to avoid the civil court action, to avoid the visit of labor inspectorate and to get more improvement notice, to avoid the closure of business and to avoid the provision notices and to comply with the minimum legal requirements, so they will not be uh, become the defaulter of the legal requirements, to avoid the publicity damages and to avoid the court orders. So we can see there the so many regions are there. That's why the organization is complying the legal requirements. Now we can have a look on some sample questions, like question 1. What are the consequences that could be faced by the employer when they breach health and safety legislation? So it may be like verbal warning, then improvement notice, next the provision notice, and then imprisonment. Yeah, same question like what action an enforcement agency may take following an accident at work. If any accident happened, then legal authority will be coming and directly issuing the provision notice to suspend the activities of the organization, and then they will be starting the investigation, and then they will be analyzing, and they will be taking the further decision to impose the penalty or fine. We can see the question 3. What action an enforcement authority might take if it is find that an employer is not fulfilling its responsibilities? So here they may issue the improvement notice to the employer, and to comply with the legal requirements, and they may advise him to how to implement the health and safety. They may assist him in development of health and safety policy and implementation of the control measures in connection with the legal requirements. The question 4, what action that an enforcement authority or agency may take if a workplace is unsafe? So question 3, like a question 3, the we can, if they find that unsafe workplace, then they may issue the improvement notice and help to the organization to fulfill that the breaches of health and safety legislation. We can have one more question. It is common for the labor inspectorate to ask labor inspectors to visit a workplace following notification of a workplace injury. So the labor inspectorate or the labor department or HSC authority got a notification that some accident happened in one organization, then the labor inspector will visiting that workplace or that particular organization. So what are the function of labor inspector that we have seen into the previous slides, and what are the action the labor inspector could take following the visit? After the visit, he may decide to impose the penalty or the fines or to prosecute him. Yeah, what appear to be the legal reason for the way health and safety is managed at the workshop. So they will be checking the why the, if any control measures were applied. So then what are the, why they are applying the legal point of view, what are the, how they are managing the safety at the their workshop or any warehouse or any workplace. So we can see from the, by visiting at the workplace, the labor inspector will visit physically at the workshop, and they will find out, yes, they have implemented the control measures or displaying the health and safety information, and they are not operating any machine which is unsafe or without the guarding. So by seeing the particular scenario or the case study, we can write the answer of this question. Thank you.